Imagine this, your marriage is crumbling. You secretly record your spouse's explosive phone calls admitting cruelty, but the court throws it out. Privacy breach. Sounds unfair? The Supreme Court just flipped the script. In 2025's blockbuster ruling, secret spousal recordings are now admissible in divorce cases. Today we break down Vibhor Garg versus Neha, the case that's changing Indian family courts forever. Stick around, this could save your case. Here's the backstory. Vibhor Garg, a husband from Batinda, Punjab, sought divorce citing mental cruelty under Section 13 of one of IA of the Hindu Marriage Act 1955. His key evidence, years of secretly recorded phone conversations with his wife Neha, capturing abusive language, threats, and toxic behavior. The family court admitted the recordings as valid electronic evidence under Section 65B of the Evidence Act, applying the spousal privilege exception in matrimonial cases. But the Punjab and Haryana High Court 2021 overturned it, calling it a direct violation of the wife's Article 21 privacy rights. Recordings excluded. Vibhor took it to the Supreme Court. The big question, can private snooping disqualify crucial proof? Neha won, recordings banned. Vibhor appealed to Supreme Court via SLP. High stakes, does snooping kill evidence? Fast forward to July 14th, 2025. Justices B.V. Nagarathna and Satish Chandra Sharma delivered the verdict. High Court order set aside and family court restored. Here are major highlights. 1. Section 122 of the Evidence Act shields spousal communications, but only against compelled disclosure. In divorce, where one spouse is voluntarily accusing the other, the exception kicks in, no blanket privilege. 2. On privacy. As observed by Justice Nagarathna, when spouses resort to recording each other, it signals the marriage is irretrievably broken with zero trust remaining. Courts won't ignore that reality. The recordings often prove the cruelty directly. 3. In modern context, with smartphones ubiquitous, properly authenticated recordings via Section 65B certification are admissible between spouses only, not involving outsiders. Final call, if relevant, authentic and untampered, they're in. No absolute privacy bar in bitter matrimonial battles. This ruling marks a major shift, closing loopholes where privacy claims blocked proof of cruelty. It empowers genuine victims to substantiate allegations with digital evidence. However, risks remain. Improper recording, hacking, or sharing with third parties could still violate the IT Act. Courts insist on strict forensic verification and Section 65B of the Evidence Act compliance to prevent misuse. Here are some key practical tips for you. Record wisely. Limit to direct spousal conversations. Secure a Section 65B certificate immediately. Build your case. Leverage for proving mental cruelty under HMA Section 13. Steer clear of pitfalls. Never involve or share with outsiders. Keep it strictly matrimonial. Applies both ways. Wives can now use recordings against husbands too. Act promptly. This 2025 precedent bolsters stronger divorce petitions. Always consult a qualified lawyer. Cases vary greatly. The Supreme Court has brought clarity and balance to family courts. Vibhor Garg versus Neha, 2025, full judgment linked in description. If this surprised you, hit like, subscribe for the latest Supreme Court family law updates, and share your thoughts in comments. Up next, massive alimony battles. Stay informed. See you soon.